Quorum, and it's 8:45, and we have with us this morning Philippe Bensimon, Dr. Philippe Bensimon, Dave Blackburn from the former member of the Parole Board, and from the John Howard Society, Catherine Latimer. Mr. Blackburn, I understand you want to go in not in order, but a little later in the order. In which case, if it's all right with Dr. Bensimon, we'll start with you. So 10 minutes, sir.
Thank you, sir. Alors, d'abord.
Thank you. Good morning, ladies and gentlemen, members of the committee. Before I start...
To stand, but you're welcome to if you wish.
Thank you very much. It's just for the short presentation.
Okay, that's
Thank
fine.
you, sir.
Thank you.
Donc, j'aimerais d'abord me présenter, ce qui va...
Allow me to introduce myself. This will allow committee members to better target their questions. I have a doctorate in criminology. For 27 years, I worked for Canada's Correctional Service, 15 years in 5 different penitentiaries as a parole officer. And then I worked 12 years in operational research for the Correctional Service of Canada, and then 20 years of teaching at university in criminology at both Ottawa U and the University of Montreal. And I've written 50 publications published in various international criminology publications. And now I am an expert in the analysis of the level of dangerousness for various courts. So, in the short time I have this morning, I'd like to remember committee members that to make sure you understand what follows, that there is no training school, there's no university to teach a person how to become a parole board member. It's not a profession or a specialty, but it's a function. Further, the Parole Board of Canada is only one link in the chain. Here we are trying to understand who is guilty, who is responsible. People are pointing fingers elsewhere, and to understand how a person was killed in the case we are studying, which is not the first time this happens in Canada. I have to come back on the history of the Parole Board so we can understand how we got to where we are today. Not so long ago, following the Fauteur and Archambault Commission reports, well, in 1956, the Parole Act was passed, and 3 years later, the National Parole Board of Canada was created. And that was going to change its name several times. Today, it's the Parole Board of Canada, made up of, at the time, people chosen, appointed by ministers and MPs who made recommendations to the PMO. So those were very political choices by whichever government was in place. Now, at the time, there were high recidivism rates. The Canadian public had a very negative perception of the parole board. The members of the board were often criticized for their lax decisions. And it was only in 1994, when Willie Gibbs arrived on the scene, that things really changed. From then on, candidates would be judged based on their knowledge, their ability to hold a fulsome interview during a hearing, and we made sure that decisions were fair and enlightened. So at the time, candidates were chosen based on a competition with 4 distinct steps. Step 1, a written test. If the candidate passed that test, there was an oral test. And the written test wasn't simply a matter of preparing readings for a few weeks, but it was a preparation of several months, even a year. And then if the candidate passed that first written test, there was an interview with 4 experienced members, scenarios on how to act, role-playing, ability to verbalize, and abilities to make decisions. And then when both of those tests were passed, the last point was to make sure that a candidate did not have a criminal record, and that person would then be mentored for at least 6 months by an experienced commissioner, and feedback would be given. But during those 6 months, the candidate was taken under the wing of more experienced members. Now, Then there was a training of 15 years per year for each following year. Whether a candidate was more conservative or liberal, more to the left or more to the right, just like we are here in the table, not everyone could become a parole board member. These members don't don't follow a certain plan. Everything that went into the training of candidates fell under the parole board. There is only one expert, the parole board member, who usually has a background in criminology. The Correctional Service in Canada has a mandate to recommend or not whether an offender should be freed, and it is only the Commission which is in a position to make a final decision during a hearing. Now, if we're trying to point fingers before a decision is taken, means that we are not taking into consideration the entire context of the Correctional Service of Canada. Now, Mr. Gallese, his case is not an isolated case because back in the day, such cases did happen. And in this case here, a prostitute was involved, and this was recognized by the Correctional Service Commissioner of Canada. Now, Mr. Gallese had a heavy criminal background. And we know that under Section 286(1) of the Criminal Code, there is subject to a fine of $1,000 to $5,000 in cases of reoffending. The authorization was signed by the parole board member and was co-signed by other authorities. Another mistake is that an offender should never be put into a halfway house, which falls under federal jurisdiction, when that offender has a heavy criminal past, including murder and sexual offenses. So such a person should never be put into a community situation. We know that the media coverage was extensive, and provincial, or rather halfway houses fall under provincial jurisdiction, even though they originally are house offenders from the Correctional Service of Canada. So in these halfway houses, these provincial halfway houses, you have provincial offenders who have been condemned for sentences of under 2 years, with offenders who have committed much more serious crimes and who have been in federal penitentiaries. So you have a mix of offenders, and this should not happen in these halfway houses. You have provincial offenders, less than 2 years, which are one type of offender, and then the criminal ones who are a different type of offender, and the two should not be mixed. In these halfway houses, you have all kinds of people who work there. You have volunteers, you have students who are doing an internship, you have various kinds of social workers, and again, all these people are working together in the community. Now, if we want to limit the risk of reoffense, the risk of reoffending is never zero. This is an illusion. At one point, there were 4 parole board members that made decisions on offenders who had committed murder in the past. So we need more commissioners on parole boards for heavy offenders. Thank you very much.
Are you ready? Okay, 10 minutes, please.
Merci, Monsieur le Président, et aux membres.
Thank you, Mr. Chairman, and dear members. In the full interest of transparency, I was a Conservative candidate in the in the last election. I'm extremely sad about what happened to Marlene Lévesque. She never should have died the way she did. The consequences were horrible. And it was obvious that this would have happened. Why? Because the Correctional Service did not do its job. This murder is the result of a series of failures within the chain, which started with the Correctional Service all the way to the halfway house. Changes to the appointment of commissioners have had disastrous consequences on the way this independent parole board operates. Canadians, the family of Marlene Lévesque and the daughter of Chantal Deschênes, who was killed by Galaise years ago, want clear answers on the failure of the Correctional Service, of the Parole Board, and they want to make sure that women in Canada are better protected in future. Commissioners Lindy and Fortin made a bad decision in September of 2009 by allowing Galaise to go to a halfway house. Those commissioners did not have a lot of experience in risk assessment, and this was a complex file. The members did not protect society from this murderer. At the hearing, the two commissioners were informed of the strategy of the case management team of the offender, which was that he should be able to meet women so he could meet his sexual needs. This was new information, and commissioners should have gotten more information about this strategy in order to better evaluate the risk that Galaise presented to the public and to women. Further, the commissioners just wrote down a few lines with regard to the inappropriateness of this strategy. They did not evaluate the risk and did not impose the security measures which should have been implemented. I don't see how this strategy, allowing Galaise to meet women, to meet his sexual needs, could have in any way led to his rehabilitation into the public. I've never heard of this kind of strategy throughout my entire career, and I was shocked at the comments of the union.
We're into kind of some delicate territory here as to evidence. There's evidence that's direct evidence, there's indirect evidence, and then there's hearsay. If you're going to cite, make reference to something, it would be helpful if you could cite it so that we're relying on evidence as opposed to what might be something somebody said about something. That would be helpful in terms of the committee's deliberations. But I just say that to all of the witnesses for the purposes of trying to stay within the parameters of evidence as opposed to what others say about something else. So I'll let you go forward, and certainly we're not going to penalize you in terms of time, but appreciate your presentation. Thank you.
Donc, de toute vraisemblance, la stratégie ne protège.
So the strategy did not protect women, and clearly there were failures in the system. Lastly, the Correctional Service and the halfway house have to explain why they were so lax in monitoring this man. Second point, in the past, commissioners who wanted to have their mandate renewed had to write a letter to the chair, and the chair recommended yes or no to the minister. And this way, good commissioners got another mandate and bad ones did not. In March of 2016, when I asked for my mandate to be renewed, but I was told that the Trudeau government would implement a new appointment process for parole board members. A bit later, the national office told me I had to reapply and start the entire process from the beginning. So the old renewal reappointment process had been abolished. In the meantime, a dozen commissioners in Quebec, including myself, started discussions on how these changes would affect the mandate of the parole board. For us, these changes would have a major impact on the way the parole board operated. There would be a loss of expertise, of knowledge and experience. There would be a lack of control over the hearings, and commissioners would be overworked as well as their staff. And at the end of November 2015, we sent a letter to Prime Minister Trudeau and a letter to the Minister of Public Safety, to the Clerk of the Privy Council, and we shared our serious concerns. And here's an excerpt from that letter. An organization like ours needs new commissioners on a regular basis, but the board also needs experienced members and enough of them who have had good careers in order to keep the institutional memory alive. So, and also because new commissioners need to be trained over 18 to 24 months. And this is all needed to protect the public. Our first mandate is to protect Canadians. And we believe that these changes are going to imperil that mandate. Further, we asked the Prime Minister maintain the old process of renewing the mandates of commissioners, but we did not get any answers from any of the people we sent letters to. We don't understand why. The letter shared serious concerns because we were afraid the changes would undermine the protection of the Canadian public. I ended my mandate in January of 2018 at the Parole Board, and I spent less than 30 minutes in front of a selection committee. None of the members on that committee had any experience previously as a Parole Board member. So I believe that in this Galaise affair, the murder happened as a result of changes brought about by the Trudeau government. The Parole Board lost its autonomy and independence when it came to appointing new commissioners, and therefore, most of the people who had a lot of experience, who had been previously appointed, had been shunted aside. And what was strange about this new process is that a member of the selection committee had been appointed by the Office of the Prime Minister. The first vice president appointed in 2018 was Ms. Sylvie Blanchette, and while her husband was an influential minister from New Brunswick, that was well known. And Ms. Blanchette influenced decisions as to who would be appointed or not on the list of potential candidates for the Parole Board. And by eliminating the old process, which kept experienced members, well, a lot of these members, as a result, were moved aside. The new process was a way for the Trudeau government to appoint the people it wanted, but unfortunately, this change was made to the detriment of public safety. The commission was unable to deal with the fact that it lost so much institutional memory over a few months. Part of the hard work of a commissioner happens on the ground and in the course of the hearings it holds. Experienced commissioners are mentors for new commissioners. They transfer their knowledge, their expertise, and then and this way new commissioners properly know how to assess risk. And the fact that this mentorship disappeared is what was missing in the Galaise case. Experienced commissioners would have seen that this new strategy to rehabilitate Galaise would not have worked and would have imperiled the public. So let's be clear here. The Quebec region of the Parole Board was purged of experienced commissioners in 2018, and the numbers speak for themselves. 2 experienced commissioners out of 16 survived this purge. None of the others were renewed without any explanation, so 14 new people came on board. This didn't make sense, and furthermore, I learned that the Liberal Research Bureau had made an investigation. An anonymous source sent me a document dated from the spring of 2018. This is extremely concerning and does not represent a practice which should happen in a country like Canada, which is based on the rule of law. The appointment process changes undermine Section 3.1 of the Correctional Services Act and the Parole Act, which says that the protection of the public is the number one criteria. In conclusion, the internal investigation ordered by the Minister of Public Safety will not shed light on everything that went wrong and that led to the murder of Marilyn Lévesque. And the strategy applied by the Parole Board and by the case management team turned out to be nothing more and nothing less than criminal negligence. It is necessary that an impartial outside investigation take place and that the results be made public. We need to understand the chain of failure which happened in this sad affair. This tragedy does not only affect sex workers, but all of society. Again, Canada has to understand what is happening in parole boards in other countries, including the UK, where in some cases there are 3 parole board members who are supported by experts and criminologists and whose political leanings need to be identified to get the answers we need, especially with regard to this new appointment process. Prime Minister Justin Trudeau must be questioned because he is the one who called for these changes. Otherwise, we could have avoided this murder. My full sympathy goes to the family and friends of Marilyn Lévesque. Thank you very much, Mr. Blackburn.
Thank you very much, Chair, and thank you, committee members, for the opportunity to be here. The John Howard Society of Canada would like to extend its condolences to the family and friends of Marilyn Lévesque. The death of a young woman is undeniably tragic, but to learn that she was murdered by a parolee who had killed a woman before is devastating. I think we all hold the belief that someone under sentence for a murder, subjected to strict conditions and monitored by state officials in the community, ought not to have been able to take someone's life. While it is rare for a parolee to commit a violent offense, let alone murder, I think a full and impartial investigation into how it happened is needed to ensure that the mistakes are identified and corrected. We hope that having this parliamentary committee seized with the review of events leading to Ms. Lévesque's death will lend objectivity and transparency to the process. I'd just like to indicate that I am not familiar with the particular facts of this situation, so I have no direct evidence to offer the committee. But I do know that violent offending by parole by people serving their sentence in the community after prison is rare and has been declining. And I think you'll find that when you look at the statistical reporting on this, which leads me, if I can just comment on the implications of Mr. Blackburn's presentation. I think a reliance on the ways of former board members and thinking that that is a better way might well be contraindicated by the statistical indication of improvements to the way in which the parole boards are making decisions. That being said, I think it's very important that there be a full investigation that tries to identify what the actual problems were in this particular case. And as it pointed out, decisions about release are kind of a confusing area because it is both the Correctional Services of Canada and the Parole Board of Canada who are intimately involved in coming up with the decisions for prisoners who are serving more than 2 years. And they share the responsibility for release. And that means preparing prisoners for release, deciding when they should be released, what conditions they should follow, monitoring compliance with those conditions, and suspending and revoking releases if the risk cannot be safely managed in the community. And the challenge is knowing which agency is responsible for what part of that continuum. And it's not entirely clear because the word parole factors in it all, which leads to some misperceptions and some public misunderstanding about who's responsible for what. CSC is responsible for preparing prisoners for release, usually through correctional plans, and monitoring compliance with conditions when they're in the community that are established by the parole board. So that's essentially the operational wing of this. They're dealing face-to-face with the prisoners in the correctional facilities and in the communities and preparing them and seeing that there's progress being made against these correctional plans. The National Parole Board, I'm showing my longevity in the area, the Parole Board of Canada decides when people should be released if they are eligible, what conditions apply to their release, and whether conditional releases should be revoked. So they're the decision makers, and they're pretty much reliant on evidence coming from CSC in terms of the factors upon which their decisions should be based. And these are difficult tasks, and they're guided by risk assessment tools. and an understanding of an individual's criminogenic factors. But predicting future behavior is never absolute. And the statistics, as I mentioned, suggest that this is working well and, in fact, improving in terms of community safety. But clearly something went wrong in this case with tragic consequences for Ms. Levesque. While both CSC and Parole Board Canada are conducting reviews, many of us favor an external review to ensure transparency. But external reviews run the risk of overly harsh constraints and a culture of risk aversion to address public fears. And this, in the long run, can undermine public safety. So in the federal prison population, about 2/3 of those in there are there for having committed violent offenses. Okay, so the propensity, there is a past evidence of violence for a good chunk of the people that we're dealing with. And roughly 1/4 of the total federal prison population are serving indeterminate sentences, and they can only get into the community through parole. 3/4 of the federal population have determinate length sentences set by sentencing judges, and they will be released into the community whether or not CSC and the Parole Board of Canada think it's a good idea. So I think Chairperson Oates, when she appeared, indicated that about 60% of the conditional releases are due to statutory requirements and not at the discretion of the parole board. Members of this group generally are not getting the correctional programming and reintegration support they need. Most concerning for me are the high-risk, high-needs prisoners who have been detained by the Parole Board of Canada until warrant expiry or until the very end of their sentences based on fear that they would commit a serious personal injury offense before the expiry of their sentences if they were released earlier. After the end of their sentences, they would no longer count as a failure of the paroling or conditional release system, but they're no less likely to commit an offense. And they are being asked to find their way, often after long periods of prison, with no support from correctional services. We have prepared a number of podcasts called Voices Inside Now. The first 2 episodes are talking to 2 prisoners who were released at warrant expiry. And I think there's a real concern about that. So to address public safety, our view is that Correctional Services of Canada and Parole Board of Canada need to apply resources and efforts to higher risk prisoners and not focus efforts simply on lower risk prisoners who might well be more successful on day parole. I would worry about any recommendations coming from review committees that had the effect of discouraging CSC and the Parole Board of Canada from preparing all federal prisoners for reintegration and supporting their graduated and supported supervised release. Risk aversion that can happen as a result of tragic incidents have a price in terms of public safety. I think we need to be worried about that. I'm very hopeful that MP Bragdon's Bill C-226, which proposes a federal framework to reduce recidivism, will receive second reading and come to this committee. It would provide an opportunity to make progress on reducing recidivism and promoting community safety for all. I know that some are asking for this committee to look beyond the situation of Mr. Gillese and Mademoiselle Levesque and look at the general competence of the parole board, the efficacy of their appointment processes. And if they're proposing to do that, I think you also need to look at those who have been breached in the community, had their parole suspended, and have been treated unfairly by the processes as indicated by the courts. And I raise in particular, as evidence of this, the case of Jim DeMaria, who had been released by the parole board and has served in the community for 20 years without breaching. And then he was suspended, placed into corrections for having attended 2 weddings that were approved by his parole board, his parole officer. And he has been in there for about 6 or 7 years with a consistent failure being recognized by the courts to deal with him in a fair and impartial manner. So I think that there is clear evidence of the kind of rigidity and risk aversion that can actually hurt people's rights and security interests and public safety if there is too much of an emphasis on being overly cautious with. But in any event, we need to understand what mistakes were made that led to the death of that particular woman. And I wish the board, this committee, all the best in coming to terms with that. And if I can be of any assistance, I would be delighted to do so.
Thank you, Ms. Latimer. Monsieur Paulus, 6 minutes, s'il vous plaît.
Merci, Monsieur le Président. Merci, Madame, Messieurs.
Thank you, Chair, and thank you, ladies and gentlemen, for being here with us today. Mr. Blackburn, last Tuesday, when we met the Chair, Jennifer Oates, of the Parole Board of Canada, we discussed Commissioner or member of the Parole Board experience. In the purge in 2018, according to you, institutional memory was removed and shifted. And the chair mentioned to us that from experience, there were a number of cases that had to be heard by a member before they were apt. How many cases, according to you? I can't tell you just off the top of my head because someone can indeed judge a number of cases, but if the results aren't quality results, that doesn't mean much. One of the criterias to evaluate a member is indeed that, the quality of the decisions they make. It's more about quality than quantity. As for experience, you know, the experience of a member of the Parole Board, as my colleague mentioned earlier, yes, some of it is learned on the job. The 5 or 6 first weeks, for example, of training that's offered, you learn a number of things about the Parole Board and so on. And then there's real work. Members who are present are able to provide mentoring. But there's another matter of great importance. What is the background? What type of diplomas do they have? What type of education? What have they studied? Criminology, social work, or something else that may or may not be directly linked to Parole Board work? Also, how much have they learned in the field in the past? So it's not merely the number of cases they hear at the Parole Board. So when we look to the Galeesi case, more specifically, we look at the release plan that was provided. Some aspects of it were not accepted by the member. What decision should the member have taken, actually? Well, I think it was certainly a problematic situation. This is how it works in a hearing. When you receive new information, which occurred, they learned right there in the hearing that there was a strategy that would allow him to go and meet women to meet his sexual needs. That information needed to be taken into account. You needed to find all the information about it, all the details about it, in order to better weigh its possible effect on the risk level. So would the member need more experience or lack judgment, or what was the issue? I would say both, lack of judgment, lack of background, because that sort of strategy makes no sense. I mean, tossing the wolf into the hen pen makes no sense. What I believe he should have done would have been to simply revoke the day parole until the correctional services were able to provide more information about the strategy. As for the letter that 4 prior members wrote to the Prime Minister, have you a copy of it? Yes, I do. Chair, I would like us to receive this letter here in the committee so that we can learn more about it. Thank you. So the work situation within the Parole Board of Canada after 2015, would you say it was a negative workplace or not? What was the change? Well, more work was demanded of the members, and I can give you an example. I would get there at 8 in the morning, and then there were votes to be taken on the file. For that, at 8 o'clock, I took 10 minutes to eat something, and I was back on the train at 4:30 in the afternoon. It was go, go, go to be able to cover all the work I was given for that day. Often I would get into the train, sit down, and I would remain quite anxious because I was wondering whether I had made some decisions too quickly. So indeed, this had an effect on the members and some of the clerks as well. Some took sick leave at that time. There were changes over time. And sometimes when members would leave, there were positions that were left vacant that weren't filled in 2016, 2017. So those left had to work harder. Thank you, Professor Simon. The Sophie Grégoire's parole conditional release officer had given them a specific release. As for Galeesi, though, was there any specific requirements for community follow-up? Well, I can tell you that there is a good deal of waste in correctional services. There are a lot of people involved, too. There are 2 professional groups that we must really pay more attention to. We need 2 times more parole board officers, community parole officers as well. Why in the community? Well, because once the inmate is released to the community, statutory or day parole, there isn't anyone out there to keep track of them. And the parole board officer is the only one involved. So they're out there in community centers where the personnel, of course, can be very involved, people who absolutely love what they're doing, but that's not the issue. You should not be putting federal inmates with provincial inmates unless the federal offender has been found guilty of crimes with no more than 7 years sentence. If you really want to change the situation, because every time there's a major issue, I can remind you that people remember them, there have been conditional release officers who have been killed. And every time committees are struck, the preventive measures are taken. You'll remember Mr. Roch, a young criminologist who was assassinated at the Community Release Center Fitzpatrick in Ottawa here, which was run by the John Howard Society. And Correctional Services had intervened to say that any offender with an offense with violence was not to be released.
Unfortunately, maybe just for the help of the witnesses in particular, we have what is now a 6-minute round.
It's okay, no problem.
Yeah.
I will come back.
Exactly. And if you just take a look at the chair from time to time, and then I don't have to interrupt the flow of what people have to say. So Ms. Damoff in particular is very skilled at her managing her 6 minutes.
Thank you, Chair. That's because I timed myself.
Yeah, there you are.
Thanks to all the witnesses. Ms. Latimer, I want to thank you for the good work that you do in keeping the public safe by reintegrating offenders into society in the way that you do. I just want to sincerely thank you for everything you do. Mr. Blackburn, I just want to clarify something that you were alluding to. We had the chair of the parole board.
Est-ce que c'est pas une écoutette? Ah, oui.
We're not timing right now, right? No. Good. Sorry. Okay.
Ground zero.
You implied that the Parole Board of Canada had condoned the gentleman seeking out sex workers for sex after he was released. But Ms. Oates was very clear when she was here that they did not approve that. So I just want to clarify that for the record, that the Parole Board of Canada did not approve this offender to seek out sex workers or paid sex after he was released. My question for you, though, is you've been quite outspoken on this case, and I'm just wondering, did you see any of the information that was before the parole board, reports from the case management team, the risk assessments, psychological reports? Were you present for the hearings? Any of that information, do you have that available to you?
Les seuls et uniques renseignements que je possède par rapport à ça, c'est les documents qui sont publics, c'est-à-dire la décision de la
I'm
commission.
not getting translation.
Only information I have on this topic are the public documents.
Les seuls documents publics.
The only documents that I've been able to consult on this case are those that are public in this file, that of Eustacio Galés, the Commission's decisions in September.
Decisions on news reports, or did you base your decisions on the information that was in front of you?
Ça va de soi que les décisions, quand on est commissaire, sont prises avec l'information.
Well, obviously, the decisions, if the decisions are made in a quality way by the members and the information is based on quality information. But in this case, given the decision, well, my comments are about the decision made by the members. So it's not about the news, really. I simply looked at the decision rendered, and yes, you say that it wasn't approved by the members, but they didn't take any measures to protect society when they learned the new information.
Present at the hearings, you don't have access to any of that information. So with respect, you're speaking from a place of hearsay and news reports. What happened to this young woman was absolutely tragic. And none of us condone what happened. We send our sympathies to the family. We also know that they're extremely rare. In 2014, there was a gentleman that was found guilty of murder who had been released, and Mr. Harper never even called an inquiry on it. It was Christopher Faulkner. Now, no one condones those kinds of murders, but we also know, the correctional investigator was here, that they're rare, they're extreme, and we don't make policy based on a few bad decisions. Now, you made a statement that this murder could have been avoided if the appointment process were the way it was before. Is that what you said? I wrote down we could have avoided this murder because of the appointment process. Is that correct?
Oui, juste une précision, ce n'est pas basé.
Well, let me specify, it wasn't based on news, but on the decisions taken by the members. So if you're in a hearing and you will make a decision.
Process was responsible for this murder. So in Quebec, 8 out of 9 appointments were men, 6 out of 9 were conservative. So you're saying that conservative staffers, donors, and candidates make better candidates for the parole board than the women, Indigenous peoples, and visible minorities, because that's what Mr. Paul Hughes implied on Tuesday. So these people, it's independent, they are getting training, and I'm just curious why a conservative candidate makes a better person on the parole board than the people who've been appointed.
Premièrement, j'ai été
Monsieur le
candidat
Président.
conservateur.
Well, to begin with, Chair, I would like to request that my colleague withdraw what she has said, because that's not at all what I said on Tuesday. Perhaps there was a problem with the translation, but I never said that conservatives were better than women or Indigenous peoples.
To the motion that was referred by the House, and it includes a review of the changes brought about by the government in 2017 board's nomination process, with a view to recommending measures to be taken to ensure another tragedy such as this never happens. I think it would be more useful if we could not reference liberal appointments or conservative appointments, but stick with the nomination process. There appears to have been a change in the process in 2017. I think the utility of our deliberations might be helpful if we steered clear of whether these were conservative nominations or liberal nominations or themes and variations thereon. So with that, I will not restrict the members' line of questioning, but that's the opinion of the chair.
How much time have I got left?
You've still got 2 minutes, sorry.
Okay, thank you. Okay, I'm going to leave it there and move over. Well, actually, I'll ask you one last question. Do you think sex work should be decriminalized?
Préalablement, est-ce que je peux répondre à la question que vous m'avez posée? J'ai
No,
pas eu-
Well, can I respond to the prior question?
Be decriminalized, because we know that that's one of the factors that led to Ms. Levesque's murder.
Personnellement, je ne pense pas que le débat se situe à ce niveau-là.
Personally, I don't think that that's what we're debating. I think that what we have here is a young woman who has been murdered. It's one extra murder. We don't need it.
Led to her murder, though. So I'm just, if you could just answer the question.
Ben, personnellement, je pense pas que le débat est à ce
Personally, I don't think that's what we're debating here. What we're talking about is problems at the parole board.
I'm going to turn it over to Ms. Latimer, just if you could. How common is it for this type of situation to occur? How many people actually, including murderers, past murderers, are able to reintegrate to society and not offend?
Actually, the recidivism rate for people who've committed murder is one of the lowest recidivism rates. that we know of. These tend to be one-off incidents. Just to go back to Monsieur Ben Simon's case, our halfway houses have a lot of people who have committed murder in the past and are making their way into the communities, and there are lots who have made significant contributions in the community without ever reoffending.
You talked a little bit about statutory release.
Right.
Could you explain why it is actually safer for the public, for people who are low risk, to be released into a halfway house versus spending time in prison until their statutory release?
Sure.
Briefly, please.
People who are coming out at statutory release may not have had the preparatory programs and support to persuade the parole board that they are ready to be released, but they're coming out anyway. So it's very important that we continue to support those people with programs and support. There's no question the statistics show that the safest way to release people is through parole and through the graduated mechanism. But we could be
We're going to have to leave it there.
The
Thank you,
ones.
Ms. Damoff.
Okay.
Madame Michaud, 6 minutes, s'il vous plaît.
Thank you very much, Mr. Chairman. Good morning, and thank you for your testimony. I'll begin with you, Mr. Blackburn. You said in your opening statement that there was a series of major failures within the Correctional Service of Canada. And what we learned last Tuesday, and in fact from the beginning of this study, is that this was an isolated case, that this hasn't happened before. But the union is saying that people who were out on parole did go to massage parlors. And did you see that in the past? No, in my career, I've never seen that. Whether in university or as a professional, I've never seen that kind of strategy. And I can't explain why this kind of strategy is relevant clinically or therapeutically or from a correctional perspective. There's nothing in the strategy which would help an offender rehabilitate by going to a sex worker. I've never seen that. And for me, that kind of strategy is concerning. It's worrying. And just to put things into context, it was the parole board member that proposed the plan, or rather the case management team that proposed the plan, and the parole members are the ones who have to make the ultimate decision. Well, look, there's a series of documents involved. Once, the assessment by the case management team that's presented by the parole board member, and then the correctional plan is updated. There's a psychological evaluation. So all the information is contained in the offender's file, and there's usually a plan for the release. So the offender will work here, will rehabilitate there. And at the hearing, the members go through all the documents and question the offender. Victims are present just to get more information. But when a new piece of information comes, and that happened here at the hearing, and suddenly the strategy appeared out of nowhere, well, that was completely new. It was not analyzed for risks. And in this case, it increased the risk of reoffending of the offender. So in the past, he had gone after vulnerable women, and here they're sending him towards vulnerable women working in a gray area. So the parole board members made a decision which, in my view, was not based on all the valid information they should have taken into account to evaluate the risk. And coming back to experienced parole board members, well, one of those experienced members would have jumped on that weakness and would have required much tighter conditions to limit the risk of this offender hurting someone in society. Thank you. Mr. Ben Simon, you said that this report is co-signed by authorities in place. Ms. Oates Kelly were saying the same thing last Tuesday. In fact, they categorically rejected that last Tuesday. But the report, would that have been co-signed by authorities? Well, actually, it's a pyramid. A report always requires several signatures. One is the agent or officer responsible for the file. Then there's quality control by the immediate supervisor. that supervisor signs, because after all, there's a whole case management team that's involved that works within the parole board. So, and I regret that the name of the parole officer was made public. And so somebody has pointed fingers. And when a parole board member says that she has never heard of such a case happen in the past, that's unacceptable. Murders have been committed by parolees. And those murders, about 8 per year. And these is based on research from the Correctional Service of Canada. I'm the author of one of those studies, and I'll go even farther. I'll say that out of those 8 murders on average per year committed by parolees when they're out, 10 over 10 years had already offended previously. So you're looking at one Gallacy case per year. So when I hear that 99.9% of parolees are fine out in the community, that's propaganda as far as I'm concerned. That's laughable. I'm happy to speak more to that. I'm happy to speak more to the issue of reoffending, of recidivism. I'm only here today. This is my field of expertise. I'm not going to talk about anything else. This is my area of expertise. I'm happy to answer any other questions you might have. Well, you talked about the difference between community housing centers. No, there are correctional community housing centers. They're federally run. You've got federal staff in there, federal parole officers. These are halfway houses, very structured. There's a curfew, and their expertise is working with sexual deviants, people who have committed serious crimes, people who really need to be monitors. And that's not the same as a residential community center, which is a provincially run organization. You've got different kinds of halfway houses in Canada. It's a business, actually. So what I'm saying here is that you might want to create further centers in which offenders are evaluated by people with a lot of expertise.
Witnesses that there are microphones. Mr. Harris, 6 minutes.
Thank you, thank you, Chair, and thank you for your introductory remarks to all the panelists. This is a very serious case, of course, and my first question is for Mr. Bensimon. We're dealing with 2 real factors. One is the assessment of risk. We've got a person who was clearly guilty and found guilty of a violent murder of an intimate sexual partner with a hammer and a knife, is in jail for 13 years and then released. What level would you expect the people conducting a risk assessment to know of the risk, knowing that they had this individual in their custody for 13 years, availability of programs, etc.? What would you expect to have to be put forward to a parole board to assess that risk? Would they have information about his rehabilitation or his capacity to rehabilitate? What would you expect? Perhaps I should suggest a very high degree of likelihood or positive outcome if he's going to get parole.
Thank you, Mr. Harris. J'aimerais rappeler qu'il n'y a pas de boule de cristal. Tous les détenus.
Well, nobody has a crystal ball. Whatever the offender, whatever the nature of the offense, they will all be released. It's only a matter of time. So, sure, we can have all kinds of programs. We can have all kinds of monitoring. At the end of the day, it's not the commission who will commit the act. It's the offender. If a person wants to reoffend, if a person wants to commit a crime, murder, neither you, the police, or the courts are going to prevent that person from committing that act. So zero risk does not exist. There are ways to mitigate the risk. In the case of Gallacy, I can't give you an opinion here because I haven't looked at the file. But based on what I've heard, colleagues have spoken with them. So it's not just the individual in the community at that point that matters. How long was he in maximum security? How long was he in minimum security before being released? I think in this case he was released far too early. We're talking about over 300 releases or day passes. 300? That's an aberration. I wasn't in charge of some offenders who had committed serious crimes, murders, who had been allowed out 10 or 20 times. I believe that he was released much too quickly. It was a much too quick chain of events.
The point here, the second factor, of course, if someone he was a life, he's not entitled to parole at all, ever. Only entitled to be considered for parole after 15 years, or that was his sentence. So he may never get parole. He has to show that he's not a likely risk. But then there's the supervision of him. He's still subject to a life sentence, but he's in the community, and he has supervision of conditions as a prisoner or offender ought to. That's under the control of the people who are responsible, the community parole officers. We have some information that they didn't have direct contact with Mr. Gillespie in this case, that there were third parties involved at this halfway house, that they had people who did things who weren't employed by Correction Services Canada, and they acted as a sort of liaison. What do you think of that as a method of actual supervision of an offender such as Mr. Gillespie? I'm not saying him particularly, but such as him with that kind of risk and history, that he's not being supervised directly by parole officers themselves.
Bien, merci.
Thank you, Mr. Harris. Well, I mentioned this in my preamble. There's a lack of staff. There should be 4 times as many community parole officers. The federal parole board officer should actually go see the offender in the community in the halfway house, but they're overworked. I'm not saying that if he'd been more closely monitored, he wouldn't have committed murder, but we don't know. Their halfway houses come in all shapes and sizes. Some are semis, all kinds of houses. Some offenders can come and go. I have nothing against that because some offenders are allowed to, are no problem. But these serious criminals cannot be put into community housing centers. You have to see how long he was in maximum, and then how long he was in medium, and then how long he was in minimum security. And in the case of Gallese, with all due respect, I haven't read the file, but his release was much too quick. If we don't want this kind of situation to repeat itself, I think real actions have to be taken rather than simply pointing fingers. I feel sick. And we know that it was a female parole board member, her name is made public, but it's not just her, it's the whole chain. It's much too easy to blame the one parole member who made the decision, the parole officer, because there's a whole chain of command here, and there's a lot more to say on this. I could go on for 3 days and I still wouldn't be finished.
Running out of time.
Yeah, it's amazing how that happens. Yes,
yeah.
yes.
Perhaps,
you get your usual comment at the end with a question mark.
I could possibly do that, sir. Maybe the only way I can get the points across.
It's true, but the people of Canada have spoken. Mr. Morrison.
Thank you, Mr. Chair. Mr. Benison, could you finish your conversation that you just had? I'd just like to hear the end of that, if I could.
Pas pour la question de...
Well, not with regard to Mr. Harris's question, but what I wanted to say, and I can come back to this later because it is important, people who are killed by supervised parolees, a little earlier I talked about Celia Rugrock, her murder led to a commission of inquiry, and the offender was late coming back from the curfew, and boom, it was too late. And then there was Louis Pertiger, another parole officer who was assassinated in one of these community housing centers. There was an inquiry, questions, people looked to point fingers, and the Correctional Service decided that not a single parole officer would meet an offender in community housing centers alone. It would always be two at the same time. Recently, 11 members at an Edmonton facility were fired.
Blackburn, it's interesting that we have somebody before us who was a parole officer, who is on the parole board, and we've had some comments about lack of experience on the parole boards, especially when there's a large change. I suspect the same would be for parole officers. So maybe can you step us through, you started as a parole officer, so young or inexperienced at that, although you came with experience. Your supervision, I take, came from the parole board, who helped and guided you, mentored you. And then as a parole board member, I suspect you also were helping new parole officers gain experience. Can you step me through that process a bit?
Mon cheminement personnel,
Well, personally, I have a BA in criminology. I have a doctorate in social work. I have a doctorate in a similar field. Then I did an internship with the Correctional Service of Canada in the local office in Hull as a community parole officer. And then I worked in the Canadian Armed Forces as a health officer. I was deployed in Afghanistan. I was in Germany for 4 years. I did a lot of psychosocial evaluations. And I exited the forces in 2014, and then I applied to the parole board. I went through every one of the stages. I was on the appointment list. I was appointed. And like everyone else, I had a 5-week training course, 2 weeks in Ottawa, a couple of other weeks in Montreal. And then in my first year, I was always mentored. I was always paired with an experienced member, Pierre Cadieux. He'd been a member for 20 years. He was outstanding, and he helped me learn the ropes of this job. And he also helped me to draft good decisions. He taught me how to assess risk at hearings or by going through files. So I received excellent mentorship, especially in my first year.
As a parole board member, if a parole officer came to you with a decision or a request on a condition for a parolee, and it was inappropriate, for example, would you then, talking to the parole officer, would there be some accountability? Would you document on a personnel file, for example, to say this person needs more training? Obviously, they're inexperienced, so help them with their training. Would there be documentation of what they were actually presenting? And what I'm trying to get at is, obviously, there's some accountability issue, I think. And so I'm trying to get to the point where is there documentation, like you would have reported to a director general who's on a performance pay, I suspect. So as a parole board, is there also the same for the parole officer?
nous, absolument. Si c'est un
Well, absolutely. Let's not forget that every parole board member is independent in their decision. Decisions are not necessarily unanimous. Some will say yes, some will say no, and then a second panel will be created. But if a parole officer presents something like this in the case during a hearing, well, I never would have gone there. I never would have continued the hearing. I would have asked for additional information in light of new information that was presented, or I would have spoken to the Director General for the parole board in Quebec to speak to the parole officer, because the strategy that was presented here is completely illogical. It does not make sense, and it increased the risk.
5 minutes.
5 minutes, d'accord. Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chairman. My questions are for Mr. Blackburn. To start, congratulations for your transparency and for the fact that you ran for the Conservative Party of Canada. And so now you are the chair of Peter McCain's campaign in the Ottawa, yes or no? Yes.
I
Monsieur-
love these questions. I just
No,
love
it-
these
it-
questions.
Mr.
As
Ma- No,
as
Mr.
a
Ma-
partisan, I love these questions, but it doesn't seem to me to fall within the terms of reference. I can't prevent members from asking the questions that they ask, but I would encourage members
Monsieur le
to.
Président, le témoin en début de témoignage a fait
Mr. Chairman, at the beginning of his testimony, the witness said he was affiliated, he worked for the Conservative Party. So you originally were to run for the party, is that correct? The facts in this case, most of them happened in 2017, and I was not running for any party back then. I would ask you to answer that question, please. Sure, I'm willing to answer, but I'm concerned with the question asked by my colleague, Mr. Lightbone. It has nothing to do with the fact that the witness, Mr. Blackburn, has a lot of experience in the field. He was a professor, he was a correctional officer, and now the opposition is playing politics. Mr. Chairman, I ask that we immediately stop asking politically tinged questions, because if they want to play that game, we can play that game as well. So let's put an end to this partisanship right away.
The the subject matter that is referred to us is the tragic death of a young woman, and it ill behooves any of us to have partisan issues. So I can't. If Mr. Lightbound wants to ask a question that is a partisan question, he's entitled to, as is Mr. Paulus, as is anyone else. But the terms of reference and the subject matter that brings us here has nothing, I would say, to do with things that partisan affiliations by anyone. So with that, I'm not going to restrict Mr. Lightbound from asking any question he wishes, but those are the comments of the chair.
Monsieur le Président, je suis entièrement d'accord avec vous et je suis désolé.
Thank you, Chair. I'm in full agreement with you. And I'm very sorry that we've reached this point, but it seems to me that Mr. Blackburn's testimony is very particular, and it's important to see where he's from. So do you agree, Mr. Blackburn, that patronage is unacceptable? You mentioned that in your testimony. I won't go back over this, Chair. Remain assured. But when 6 of the 9 members were partners of members of the prior government, and with the PC, 43 such appointments were made, it certainly looks like patronage. But we do agree on one thing. What counts is that member appointment be based on merit. What are your concerns about Lenné and Fortin as members? These are prior members of the Commission Parole Board. I have nothing to hold against them. I don't know them specifically. They were appointed, and in their past experience, though, you mentioned something in responding to Mr. Pierre Paulus. You said that we must keep in mind the prior experience of those members. Of the 2 members that you made implications about, those who rendered the decision, I have no concern about them. They were evaluated during the appointment process, so I'm sure that they met all criteria. You said that when you were working as a member, you made fewer decisions than these 2 members, but you say that decisions should be made well and some have not been made correctly. Do you see any other cases to mention to us? I will specify that quantity is not the issue, it's really the quality. For example, this is a medal that I received for the quality of the decisions that I made. I also have a letter from your prior colleague, Ralph Goodale. I'm certainly not questioning whatsoever your competency. But once again, it's important to point out, it's not the number of decisions you render, it's the quality of those decisions. Do you have any examples, nevertheless, of poor decisions, cases that were poorly managed, to your mind? Well, I don't know. I'm no longer a member of the Parole Board, so I can't really answer that. My question now is for Ms. Latimer. You mentioned about the experience of members and the turnover of members, that there are no statistics showing that it has a negative effect on risk management. The law allows for a maximum of 10 years as a member. Can you say more about that?
Is the annual statistical report that's put out by the government, which clearly shows an improvement in the numbers who are being released on day parole and full parole, and a reduction in the recidivism rates of those who've been released. So there's a good trend line there of showing improvement, and I think that's a good thing.
Combien de temps me reste-t-il, Monsieur le Président?
How much time do I have left, Chair?
Simon, vous avez fait référence.
Mr. Benjamin, you mentioned the fact that there should be more members to hear certain types of cases and make decisions. So why is that a useful idea? At one point, there were 4 members to hear any murder case, and then that went down to 3, a matter of budget cuts. Now many hearings are held by video conference. There's no direct contact. I mean, that's where we're at now. The officers don't have enough time to see their inmates. The members don't have enough time to, in the past, they could meet the inmate face to face, and the hearings lasted 2, 3, and even more hours, depending on the matter to be heard. So no.
Thank you, Mr. McKay. This is for Mr. Blackburn. Mr. Blackburn, could you further comment on the fact that you signaled in 2018 that the new process has put the security of the public at risk?
En fait, on a signalé ça en novembre 2000.
Yes, we made that known in November of 2017 in a letter that was drawn up by 8 members who drew up the letter and signed it. In that letter, among other things, we said we were seriously worried about the changes because we saw that colleagues were leaving the board, weren't, at that point at least, being replaced, and we felt that this would lead to problems down the road at the parole board. As I mentioned in my opening statement, it's terribly important that there be experienced members on the parole board. They are the mentors who train the incoming members. When you have nothing but new members, for example, in this decision, the 2 members involved, well, one of the might have, turned to someone with more experience during the hearing to get some specific ideas. And in 2017-18, to my mind, there were changes in the personnel. Key personnel at the Quebec Parole Board took sick leave or took retirement, which also affected the quality of the board.
Is it possible that what happened in the Montreal office with this lack of experience could have also happened in other parole board regions across Canada?
C'est une crainte.
Mr. Shipp,
Certainly a concern.
to speculate on something that is clearly not within his expertise. Certainly in any court of law, that question would be struck immediately. If you have unique expertise, Mr. Blackburn, to speculate or to offer an opinion on what was happening in other regions of Canada, certainly the committee would be interested. But if you have no unique expertise on that, I think that maybe you should at least say that in the beginning of your response to Mr. Shipley.
Ce que je peux tout simplement dire, c'est pas juste au Québec.
Well, all I can say quite simply is that changes took place not only in Quebec when it came to withdrawing members with experience.
Mr. Benjamin, you mentioned earlier about the danger of mixing provincial and federal parolees in correctional regional centers. Could you elaborate on what that danger is, please?
Quand je parle de danger, Monsieur Shipley.
Well, Mr. Shipley, danger to me is heavy cases, serious cases with long time behind bars. Risks in serious cases, and we're speaking of people who have put 10, 20, 30 years in as inmates and now moved to a transition house, a halfway house. I had a case recently in Archambault who was medium case, but he was being held in maximum. And Donnacona, he was sent into a community residential center. A very minor incident took place and his leave was revoked. These people should not be sent to CRCs. You have to bring them in, if at all, very gradually. They need to be structured. And there's also a need for personnel. These inmates need to speak to people. They need to speak to specific officers able to handle them, and not just anyone become a community parole officer. There's a lot of work required to become a good community parole officer. The risk is really the inmate, of course, not so much the officer. The officer does the best they can, but it's really the offender who will eventually act. Thank you, Chair. Mr. Benjamin, could you tell us something about the risk assessment programs at Correctional Services Canada? Are they effective? That's a question. Well, surely Mr. McKay will want to interrupt me, given that I could speak of this for hours, way beyond 2.5 minutes. I've written many important articles about this. The programs, then, yes, they do work if the person wants them to work. You can have the very best professionals on the job, but if the individual isn't ready for the program, it's not going to work. Don't forget that the inmate isn't required to use the program, to follow the program. And if they don't, well, no good for them. But an offender who does follow the program speaks of their regret, how sorry they are, how sad they are for the victims, and so on and so forth. That's their only doorway out. And very often, the officers believe on this type of programming far more than the offenders do. For example, offenders are asked, are you happier now that you've followed this program? Do you have a positive outlook on life? And who do you think that this sort of program would work for? People who are psychopaths, cartel members, criminal band members? Even with the best of programs, you're not going to get anywhere if the offender doesn't want to actually improve. Unless they've hit ground bottom, the offender doesn't want to improve. Don't forget, this is a business. You've got thousands of articles out there that will try to prove that the programs are so helpful. Nevertheless, some of them will work for certain types of offenders and for over a specific time period, but beyond that, it's really anyone's guess.
It's okay.
I'm just running out of time. And
excuse me.
My colleagues will get very
No
upset
problem.
with me, even more upset than they already are. Mr. Yakanoko.
Monsieur le Président.
Thank you, Chair. Mr. Blackburn, you said in your opening statement that this tragedy can be laid at the feet of appointment procedures, appointments of parole board members that were switched out in 2018 by the then government. However, violent crimes committed by people out on release are very rare and are becoming more and more rare. Over any 1 year, we see from 6,000 to 8,000 Canadians who are let out on some type of parole, day or full parole. And I'd like you to take note of the following years. In 2013, 14, 17 people were found guilty of a violent crime committed while they were on parole, conditional release. In 2017, 2018, this number falls to 5. In 2018 and 2019, 99.9% rather, of people on day parole committed no violent crime whatsoever. Based on this data, we see that violent crime on any type of parole conditional release is falling, even with the changes to the appointment process that you referred to. Do you have anything to say to that? Well, yes, I've got a lot to say. To start with, of course, I'm not doubting the quality of the decisions made by the parole board. The quality is there, yes. In Canada, the work is done very well, and we have to ensure that this continues. You're saying it's rare? Fine, but I'm saying any murder is too many murders. There was some sort of chain of errors here that led to this young woman being assassinated in a hotel in Sainte-Foy near Quebec City. In this area, there's no such thing as zero risk. Mr. Benjamin said so earlier. The best board member in the world, Mr. Blackburn, allow me to interrupt you. No one, and absolutely no one, wants to see murders occurring. But my question is, do you see that there is a drop in numbers of violent crimes committed on conditional release, despite the fact that you are saying things about what caused this murder, despite the fact that we can see from year to year that less murders have been committed? So my question is about that very specifically. What is behind this change, this fewer numbers of murders? Can you explain the why of the fact that in 2018 we see that 99.9% of offenders on conditional release are not committing any violent crimes, whereas back in 2013-14 there were 17 such violent crimes? I can't give you the details of that because, thank you very much. Thank you. That was a very fine answer. Thank you. Thank you. Mr. Chair, I would like to put another question to our witness. Ms. Latimer, I think you've got an idea of where I'm heading. I've explained that there are less violent crimes committed by people on conditional release at present. Can you tell us what you think led to this improvement? What might lead to such an improvement?
Factors that go into it. I think having a good case preparation, more focused programming, better support in the community, good links with community organizations that provide some support for people coming out. These all bode well for successful reintegration. It would be a shame if the focus of looking at what specifically went wrong in this case devolved to a sense of the too much into who's on the board. I mean, the quality of the decisions, I think, is varied. Sometimes back in the day you had some bad decisions, and sometimes today you have some bad decisions, but generally the quality of the decisions is pretty good and improving.
Thank you. Monsieur Blackburn.
Mr. Yacono.
Just getting started.
Mr. Trudel is not here yet, so I'm going to go to Mr. Harris for 2.5 minutes. And if Mr. Trudel comes, then we'll go to him, and then after that, Mr. Dalton. Mr. Harris, 2.5 minutes, please.
Thank you. I'd like to ask Mr. Simon or Ben Simon or Mr. Blackburn to answer this question. Ms. Danoff, in her opening remarks, indicated that the board had categorically refused to accept the so-called strategy of risk assessment, of allowing Mr. Galizzi to have his sexual needs met as part of his rehabilitation program. A CBC story says the board raised serious questions about that as a, quote, risk management strategy, but nevertheless listed his likelihood of reoffending as low to moderate, and then said the board expects the assessment that culminated in this approach to be re-examined. This seems to me to be a little less than categorically refusing to allow this to be a part of his conditions of release. Would you agree with that, or am I off base here?
De mon point de vue, c'est de là.
From my point of view, that is part of the problem. Yes, if it's turned down at the hearing level, that's fine. But if no concrete intervention is made, no specific intervention is taken at that point to protect the young woman, well, even if we say no, we shouldn't be allowed to do that. If there's no specific conditions added, that's one thing. For sure, that's not good. And then, as I said, this is new information being heard during a hearing, and such new information must be examined in depth. There should have been a call for more details. The hearing should have been suspended. The inmate should have been held until the strategies were clarified, light was shed on them, in order to protect women and people across Canada. as far as I'm concerned, only an external inquiry, totally independent, that will be able to use all the file material. I mean, I as a professional don't want to depend on journalists. I want to know what the case management really was.
Was a condition placed on Mr. Galise's release, which said that he was required to report any sexual relations that he had with women or contact with women. How strong of a condition is that if there isn't parole officers directly involved in that supervision? Would either of you care to comment on that?
We're going to have to leave it there, unfortunately. We're out to 2.5 minutes, and Mr. Trudel, are you prepared to proceed, or do you? Why don't I do this, Mr. Dalton? Why don't you go for 5 minutes?
Je pense que je suis désolé de tout ce brouhaha.
Yes, I'm very sorry for all my coming and going. Hello, everyone.
Okay.
Is that all right? Okay, so I'll go to Mr. Dalton for 5 minutes. I'll go to Mr. Trudel for 2.5 minutes, and then I'll go to Mr. Second for the final 5 minutes, because there has been a bit of back and forth, and time has been lost over the course of the hour and a half. So with that, Mr. Dalton, 5 minutes, please.
Merci. Quelques questions pour monsieur.
Thank you. I have a few questions for Mr. Ben-Simon. Can you speak to what the Auditor General said?
Service Canada calculated post-sentence outcomes. It only included the convictions that resulted in a return to federal custody. CSC did not include data on the convictions recorded by other levels of government.
Est-ce que je peux voir le papier, s'il vous plaît? Je préfère le lire.
If you don't mind, can I read the paper myself?
Let's just hold for a second so he has a chance to read.
Je préfère.
Monsieur.
Il me serait difficile de répondre à ces questions.
I think it would be hard for me to answer those questions at this point, so I'll refrain from answering for now.
Explain the case management team's strategy of authorizing sexual relations with vulnerable people. I'm thinking specifically here, obviously, of the case with Monsieur Galizy.
Bon,
Well, in this particular case, it's rare, but it's not a precedent. Now that an offender sees sex workers or anyone in this room, that's a criminal offense. It's illegal. That's pretty simple. So whether it's committed by an offender or anyone else under the criminal code, it's an offense, Section 41.
Violent incidences after release are very rare. Is this true? Vous pouvez commenter sur ça. Murders might be rare, but are there also many cases of sexual assaults, etc.? Can you comment on that, please?
Yes. Bon,
Well, I said this earlier. Thankfully, it is rare. It doesn't happen often, but as I said earlier, the Correctional Service produced a report. I co-wrote that report. The average is about 8 offenders per year who'll commit murders while on parole. And out of those 10 murderers, I gave examples, and you can look them up if you want, 10. So 83 murderers who reoffended over 10 years. So 10 of those had already committed murders. So there were 10 Galizy cases over 10 years, 1 per year. So it's not that rare. What about rapes? What's the recidivism case? Do you have statistics on rape? You mean in terms of reoffending? Yes. Now, Recidivism, that's something we could talk about for hours. But on average, in Canada, over 630,000 sexual assaults take place every year, according to Stats Can. And according to a study on victimization of those 630,000, you don't have 630,000 offenders. So about 15% of that number are offenders. Now, to give you some numbers, in 2016, 2017, 21,000 cases of sexual assault were reported by police, 33%. I'm sorry, but my time is almost up. Another question.
In the correction services effective?
Je m'excuse, je ne veux pas avoir d'erreur langage.
Sorry, I didn't get the interpretation. You're asking me whether...
With the correctional services, so effective.
Écoutez, tout ça, ça relève du détenu lui-même. Est-ce qu'il...
Well, look, it all depends on the offender. Does the offender truly want to rehabilitate himself or not? And I talked to this earlier. Well, the risk assessment grid. Well, it's like any other tool out there. You can fill it out to the best of your abilities. Does it really represent the intent of an offender? Well, you're talking about offenders who have to show true will to rehabilitate or not. I think I need more than 3 minutes to address that.
S'il vous plaît.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. My question is for Mr. Ben-Simon. In this particular case, I think there was a problem with regard to the halfway house as well, the one that Mr. Gallese lived in before he went out to commit murder. Why, Mr. Ben-Simon, do you have an opinion on why he was placed specifically in the bad halfway house or in the wrong one? Look, there are no bad or wrong halfway houses. Mr. Trudel, I said this earlier, you weren't here. There are no wrong halfway houses or bad ones, but certain types of halfway houses are more appropriate for hardened criminals. So why would you send a hardened criminal to a lower security halfway house? Well, maybe there was no room in the other halfway houses that, for instance, fall under federal jurisdiction. Like I said, there are no bad or wrong halfway houses. But some hardened criminals who have committed murder, well, you don't send them into a community housing center. It's done. Why? It's cheaper. It's cheaper to send them there than to a higher security halfway house. The staff there don't earn the same salary. It all comes down to money. You're saying the reason why he may have been sent to that halfway house was for financial reasons? Well, yeah, a federal halfway house is much more expensive because the supervision structure is very different. You can't compare the two. It's day and night. Do you think that if Gallese had gone to a higher security halfway house, he may not have committed murder? Well, staff in the federal halfway house is better trained. There are risks in both houses. But in the lower security halfway house, they're not supervised as much. You don't send a hardened criminal, someone who's spent 20 years in jail, into a lower security halfway house. Well, that's like sending a wolf into a wolf to the sheep. So sending a hardened criminal to a higher security center is a better...
Merci, Monsieur Trudel.
Final 5 minutes, Mr. Sicken.
Thank you. I may share the remainder of my time with PS Joel Lightbound. Mr. Blackburn, thank you for your transparency and declaring your partisanship at the beginning. My first quick question is actually to Mr. Ben-Simon. You stated that after 94 reforms that people had been not allowed to sit on the board because of their overt partisanship. Is that correct?
Je m'excuse, monsieur, ça ne fonctionne pas. Et je ne veux pas faire d'erreur langagière. De toute façon, la plupart des anglophones ne parlent pas français. Moi, je ne vais pas me gêner.
I just want to make sure that everybody understands my answer correctly. I wasn't getting the sound. I am completely impartial. There may have been a technical issue here. I'm sorry. Can you please repeat the question, sir?
Mentioned people had been barred from sitting on the board if they had overt partisanship.
Moi, j'ai dit ça.
I said that?
Qui ne pouvaient pas siéger.
You said that people who are too partisan should not sit on the board?
Thank you. So, Mr. Blackburn, one, I want to sincerely thank you for your service in the past. But, so here's my concern. You're being very transparent in your partisanship, which lends itself to inherent bias, or at least the perception of bias. And you constantly refer to quality, but yet you've also referred to the Trudeau government no less than 5 times. So I'm concerned about the admission. I can't personally accept what you're saying without it being partisan. So I'm a little concerned with that, and I'd actually like to ask to have a motion put forward to not accept the letter sent to the Prime Minister as evidence to be considered in the report.
The motion does arise from the actual testimony that came before us, and so it is therefore in order.
Yep.
I'm a little concerned about the time. Do you wish to present your motion now, or do you wish to present your motion at the end of the
end.
At the end. Okay, you have 3.5 minutes to finish your questioning, and then you'll present your motion.
Out of courtesy, I would like to get some comment out of this. So again, you refer to there were a lot of assertions that current changes under our government are inappropriate, yet how do you reconcile this with everything I just said? Your comment, please, Mr. Blackburn.
Monsieur, le point devrait pas être sur...
The spotlight should not be on me. The spotlight is on a young woman who was murdered in Quebec, and major changes were made to the appointment process.
Which is why it isn't about you. It's about the quality, your words, of your testimony. I'm actually going to give the remainder of my time to Mr. Joel Lightbound.
Merci beaucoup, Monsieur Scan. Petite question pour...
Thank you very much, Mr. Scan. Short question for Mr. Ben Simon. You said that as a professional and based on your experience as a former parole board member. No, I was never a member. I was a researcher and officer. Sorry, I apologize. You're saying that based on your experience, it would not be responsible to comment a case without reading the file. Why would that be important, reading the file? Well, I understand your question. I've never been a parole board member. I'm a criminologist. So to do my job, I need basic information to do my job. I don't have that basic information now. I've read what's out there. I have additional questions. As a professional, I'm not going to address certain issues because I'm very aware of what I say, and I don't want to make any mistakes or mislead anyone. That's very good, sir. I have a question for you. Miss Latimer, you originally were against this study. You were afraid that it might undermine the investigation which has been launched. So can you tell us why? Well, that was your position. I think everyone wants to shed light on what happened to make sure that this situation never happens again. And Mr. Blackburn said, one tragedy like this is one too many. So why were you originally against the study?
To find out what happened in this specific case. My concern was not against the study, but against the framing of the motion, which seemed to prejudge what was causal and what was connected with the death of this particular woman without the evidence having been presented, which would substantiate that. So I didn't think it was an objectively framed basis on which to make an inquiry into the death of an individual.
Je pourrais difficilement être plus d'accord.
Okay. Ends our testimony, and I want to thank each of the witnesses for their presentation here this morning. Mr. Sicken has, well, I wanted to do two things. My clerk is particularly excited about getting you to sign this, but we have two things before us before I can adjourn. The first is to a motion on the amount of money for this study. You've all seen it. Is there any objection to it? I don't see any objection. Done.
I just had a question. Given everything that's going on with the coronavirus, I know that one of the committees is considering having witnesses appear by video conference rather than in person. I just put that out. I don't have any problem with this.
No, we won't have any witnesses for at least another 10 days.
I know.
So this,
just for consideration.
Okay. Now, Mr. Sicken has a motion.
Mr. Chair.
It is in order because it does arise out of what we heard today. So the 48 hours is not in question. However, the motion I haven't actually seen, and I don't know whether anybody else actually knows what the motion is. So, Mr. Sicken, could you present your motion and go from there?
So actually, in light of transparency, it's okay. I would actually like to withdraw my motion.
We're all cool with that. Okay. With that, I'm adjourning, but the subcommittee needs to meet, and if and Mr. Harris.
So we have approved this, have we?
Yeah, we just did.
Good.
I saw your eyebrows twitch. It was good. With that, I'm adjourning, and then ask the room be cleared, the televisions be turned off, as it is an in-camera meeting. I thank colleagues and witnesses for their testimony.